I'm State Senator John Curran from the 41st District, representing Cook, DuPage, and Will County. I am also a former prosecutor in the Cook County State's Attorney's Office. We are here today because we are continuing to deal with a very big issue, and that is public safety and crime. As you all know, starting January 1st, we will see major changes to our pretrial detention system. This change has been discussed a lot over the course of the last year, and for good reason. This change is going to have major impacts on our communities and public safety as a whole. We've heard a lot in the last couple of days of ideas and proposals to support our law enforcement professionals throughout this state. And while many of these proposals are good, what they do not do is address accountability and holding criminals accountable for their actions, nor do they address the problems that are readily apparent in the so-called Safety Act that passed last year. We have just 3 days left in this session, and we cannot go home without addressing the concerns in the Safety Act. And just don't take it from me. We are here with frontline law enforcement officials that are going to have to deal with the very real and evident problems with the Safety Act. Today we have several state's attorneys from across this state here to discuss the problems with the Safety Act and what is going to occur come January 1st of next year. We have one state's attorney who couldn't join us today, but who told me that he currently has 48 accused murderers being held in the Will County Jail, and come January 1st, it is very likely that he will be unable to continue to detain these individuals. And I say this not to scare the media or the public, but to highlight the very real and serious implications that this dangerous law is going to have if we don't address these concerns now. Now I'm going to turn this over to Jacqueline Lacey, State's Attorney from Vermilion County, who will talk more about what this means in her community. Jacqueline?
Good morning, members of the media. When House Bill 3653 passed, it was pretty much a nightmare for most of us. I can say across the state as a state's attorney, and in a community where I currently have 24 pending murder cases in a county of 70,000 people. Danville, our county seat, has 30,000 people that live in our community, and because of the strong violence of criminal and gang criminals that travel from Cook County to Danville, it's a quick 2 hours, no iPass included. So you can make it down to Danville in a quick 2 hours, and there's a lot of difficult gang shootings between Danville people and Chicago people. So for example, yesterday we had a case where we actually charged an individual with aggravated discharge of a firearm. He was shooting as a pedestrian at a moving vehicle. We have no idea who was in the moving vehicle. It was probably, late evening hours, but on a Ring doorbell before the sun went down, we were able to identify this perpetrator from the Ring doorbell system at someone's home. Because law enforcement had prior contact with the individual, they knew who he was. He was identifiable. He was brought into custody. We were able to provide the court with a factual basis. Ag discharge of a firearm is a Class 1 felony in Illinois, and we were able to get a significant bond and hold that individual in custody and protect our citizens, our innocent citizens who are trying to live their everyday life. Under this bill, as of January 2023, I won't be able to identify who the individual person is that individual was intending to hurt. So therefore, that person would walk free. I share the same concerns that other state's attorneys do across the state, not only with ag discharge of a firearm, but there are other examples that you can look at. Armed violence. We had another case just yesterday. I mean, these are things that are happening every day in our communities. Whether you live in a violent community or not so violent community, these things are happening every day. And it's really difficult when you stop someone. For another example, armed violence. Armed violence is firearm category 1 weapon, and it's possession of controlled substance. So you get somebody who's already on bond for 2 or 3 felonies. He's stopped for an Illinois Vehicle Code violation. His driver's license is suspended. Search incident to arrest, he has a gun on him, and he has ecstasy on him. So we charge him with armed violence. We get a significant bond. We hold that individual in custody because he's already on bond for a domestic case, and now he's out carrying a firearm around, which is really significant for our victims and the harm that will come to our victims. And And with that being said, we got a significant bond and he's being held in custody. However, under this new law, January 1, he will not be held because I won't be able to name any person who he intended to harm, right? There was no person involved. He had a firearm and he had drugs. So with that being said, I know I don't want to take up too much time because there's other state's attorneys here. Eric Weiss from Kendall County is going to speak a little bit more in detail about how this new bill will affect crime across the board. So, State's Attorney Weiss.
Thank you. My name is Eric Weiss. I'm the state's attorney for Kendall County, and Kendall County is up by Aurora, Joliet. We have both of those big cities within Kendall County. I've been a prosecutor for 26 years. I've been doing the job of state's attorney since 2006. This is not a Republican-Democrat issue. I know that this is a Republican press conference, but I'm telling you this is not a partisan issue. This is a public safety issue. January 1, 2023, I'm going to still do my job. I'm going to still go to work. I'm still going to charge people with the crimes that they are accused of. We're still going to go to court. We're still going to have trials. But put yourself in the position of victims for just a moment. And I'd ask any of the people that voted for this bill how much time they took to talk to victims about what happens, or victims' families. So imagine you get a call from the coroner at 2 o'clock in the morning that your wife and your unborn child have been killed in a DUI crash. I can't imagine what it's like, but I've had to sit across the table from families that have had to deal with that. Now imagine the next morning when you come to the courthouse, I have to tell you that that person that just killed your family members, whether it's 1, 2, in my case in 2007, we had a case where 5 children that were killed in a DUI crash, that person's going to walk free the next morning. Maybe they'll have a bracelet on, but they're going to walk free because this new bill of January 1 is going to let that person walk out the door with no possibility of being held. Unless I can prove by some reason, which most people aren't, that they're a flight risk. How do you explain that to the victim? How do you explain to them that that person is going to be seen at the gas station when they're pulling up to fill up their car, the one that just killed their family, or at the grocery store, or driving down their street? Change categories for just a minute. We talk about domestic violence. And I know domestic violence is one of the cases that we can hold somebody on. But the new provision also now allows a defendant or defense attorney to call the victim at a bond hearing. Imagine you, whether you're male or female, it doesn't make a difference, but majority are female. Imagine you finally had the courage to come forward to call the police because you've been beaten. And it's probably not the first time this has happened, but you finally had the courage to call. They arrest him, you can finally take a breath. You haven't had a chance to talk to anybody, whether it's a family member, counselor, shelter, whatever it is you need to figure out what you're going to do with your life. And suddenly they come and say, oh, by the way, you're going to have to come tell your story in front of the very person that just committed the crime against you. And there's no, again, reading these conditions, we as prosecutors show that there's no condition that would allow that person to be safe. As I've been telling people before, if you're that person and you've been beaten, what kind of beating do you think you're going to get after you come to that courtroom, confront that person moments after they've been arrested? What kind of beating are they going to get after that person's released? Because there's no guarantee, just because it qualifies as a crime, that they're going to be held. Most of these people, even though they're charged with those crimes, are still going to be released. What incentive does that victim have to come forward? Do they take the beating they were getting, or the worst beating they're going to get when they get home, when that person gets out, after they've just confronted their accuser? Same with murder. You think murder, that's absolutely, we're going to detain murderers, right? That's the worst of the worst. But if I kill the one person that I don't like, and that's the only person I don't like, the law is written that I don't have a specific identifiable person, as Jacqueline has mentioned. I can't even hold you for murder unless I can show you're a flight risk. Think about that. I kill my sister for some reason, right? Financial reason. And I say, that's the only person I'm really mad at in the entire world is my sister. And that's why I killed her. Who's the specific identifiable victim at that point? Well, she's dead. I can't even, as a prosecutor, ask to hold that person at that point. That's how ridiculous this law is. Does it mean that nonviolent offenders should be held in custody if they have no criminal background and they come to court? No, that's not what prosecutors are saying. And if you look across the board, the prosecutors that do this job know that nonviolent criminals that show up to court should not be held in custody. And in most cases, they're not being held in custody already. But this bill needs to be addressed. It needs to be reworked. It needs to be done in a way that involves the people that do this on a daily basis, that have to deal with victims, involving victims and prosecutors in this process, to get it done and get it done right. So I'm going to turn it over now to Grace Simpson from the Mercer County State's Attorney's Office. She's going to talk about how cases regarding sex cases and sex victims, how this bill affects them. So Grace?
So as both the other state's attorneys have mentioned, we have to prove that this is a flight risk and that there are a specific person that's endangered. On top of that, this bill will require that proof is evident or the presumption great that this person that's charged with this crime occurred. And that is also a troubling element of this bill. Now, evident or proof is great, that isn't defined in any Illinois compiled statute as to what that burden means for prosecutors. Does it mean that we have to, and the way that I read it, it does, drag victims who have of sexual assault, sexual abuse into a bond hearing? A bond hearing is the first court date that a defendant is awarded. They're detained and then bond is reviewed. That would mean that if someone has disclosed an unwanted sexual contact, and more likely than not it's a child in the cases that I see as state's attorney. So this child has disclosed to a mother, let's say for example, that they've had unwanted contact with someone in their life in a sexual manner. And that person, after that, the way that those cases work is that they're interviewed and then the person would be detained. Immediately after that, this child would be required to come into court and to testify that the proof is great, that this person did that. Can you imagine how traumatic that would be for a child to put through? To give you an idea, when we prep a child for trial, we spend days, and we spend alternative days, consecutive days, bringing them into the courthouse to make sure they're comfortable in my office, to make sure they're comfortable on the stand, to make sure they're comfortable in a courtroom setting. That's days, weeks, if not months of work. We're asking victims of sexual assault, children, mothers, to bring all of these people, fathers, families, to drag all of these people in within hours of disclosure in order to keep this person, or potentially not, in custody. Viewing that takes the rights of those victims and completely throws them out the window. It creates an absurd result for people who have gone through traumatic incidences, as the two state's attorneys who spoke before me indicated, on top of a sexual assault. We would be asking so much of these victims who have already bravely stepped forward and not allowing officers to come into the court and find that probable cause. I believe that State's Attorney Morrison will talk more about the overall effects of this bill.
Good morning. My name is Joshua Morrison. I'm the Fayette County State's Attorney. I've been a prosecutor for 17 years. I used to work here in Sangamon County for 6 years of that term. This is my 17th year, and I've never seen anything like this in my term. The result of this law is going to be a serious chilling effect on enforcement of all prosecution of serious crime. Children and adult victims alike will think twice about calling the police. The police will have multiple cases, more cases in my opinion, on the docket. The dockets will be clogged. The dockets will continue to get more and more clogged because the defendant has no incentive to plead. The pleas only take place in some cases when they are in custody. The defendants have no incentive to plead because as long as they are out, they are going to continue to get free treatment. The worst case scenario, if they miss a court date, is they're not going to get a warrant. They're going to get a state's attorney if I am able to convince a judge to petition a judge that they didn't come to court, that I may, on the next go-round, get a petition or get a warrant for that person's arrest. And the worst case scenario, they will likely get the warrant quashed on the next time. Not the judge's fault, that's the way the law is written. The defendant has absolutely no incentive to try. And I've spoken at lots of different places, and I feel like example is probably the best way. I had a case where someone broke into someone's house no less than 3 times and then would just drive by her house and wait for her to leave, waiting for the next opportunity. He knew when she left, he knew when she worked, he knew everything about her until we could actually catch him and put him in jail. He's now in prison. But under the new law, that won't be the case. Just like the other state's attorneys have said, that person will be sitting at the gas station. That person will be eating breakfast at the local restaurant. I won't be able to protect that person. That victim may not ever even call the police the next time. That person may be killed the next time. The police are going to have more than they can handle because they're going to have another court date and another court date and another court date, and they will go on into perpetuity. I hear this from victims all the time, that the laws are basically written to protect the bad guys, not the victims. The victims don't have any rights, even though there is a Victims' Crime Bill of Rights. The victims don't have any rights. The defendants, if they want something, generally they get a continuance if they want it. We don't. We have to fight and claw for everything that we get, and the victims just have to wait. They're second-class citizens as far as it goes right now. And if this law goes into effect January 1, they're not even going to be that close. This has to change. Senator.
Good morning, everybody. I'm State Senator Neil Anderson, represent the 36th Senate District. I'm also the minority spokesperson for the Senate Public Safety Committee. Unique perspective on my behalf outside of being a legislator is I'm also a professional fireman and paramedic in the city of Moline. I see the effects of crime every day when I'm on duty. And one common thing that we've heard today from everybody is the victims, or the lack of thought towards the victims when it comes to a lot of these pieces of legislation. I can tell you from a lot more experience than I wish I had that I'm tired of seeing victims in the back of an ambulance and having to treat them, and seeing the fear that they have after, whether it's sexual assault, whether it's child abuse, or just random violence. It's heartbreaking, and it's even more heartbreaking being that we have not had a seat at the table when it comes to a lot of these pieces of legislation. Instead of holding criminals accountable, we're simply hoping the more bureaucracy and taxpayer funding will solve the problem. That's what we're seeing from the other side of the aisle. This won't work alone. We know that criminals have become emboldened by these policies that have passed out of this building by the other side of the aisle. We know that it's about to get a whole lot worse next year when a lot of these laws take effect. And fortunately, we have a compass to see how this is going to go, because a lot of these are already in effect in Cook County. We've already seen the effects of the no cash bail, like I said, in Cook County, and these state's attorneys today are not exaggerating about what is about to happen. We're not here for political purposes. We're just not. As a fireman, like I said, I'm tired of dealing with these on a daily basis. Let's call what we're seeing from the other side of the aisle what it is. A lot of these things that they're proposing are good ideas that will provide funding where we need it, but it's not going to solve the problem. When you start passing legislation that emboldens criminals and doesn't put them in jail, you are leaving victims out of the scenario. And that's what we have to change. The Safety Act has to be repealed, and we have to start from scratch and make sure we're doing this the right way.